ask. We provided the name of such a specialist to Mr. Karim's representatives the day after the ruling. That's the 30th of July. On the 31st of July, we received a response from Mr. Karim's attorney saying that they had forwarded that information to the family and to the treating doctor. You'll recall, Chair and Commissioners, that the ruling required that if there is no agreement on the proposal from the evidence leader side by the 3rd of August, that then the president or the chair of the professional association should nominate an independent specialist. So we heard nothing further from Mr. Karim's attorneys. And so we wrote again on the 3rd of August, the deadline, requesting a response by 10 a.m. on the 4th of August, especially a response as to whether Mr. Karim has consented to an independent medical evaluation, because we were concerned with putting things in motion and putting people out unnecessarily. We also indicated in that letter of the 3rd of August that if we didn't hear back from them by 10 a.m., that we would then contact the president of the association in order to set things in motion. No response was received on the 4th of August. We approached the president, who nominated a specialist. And we thank the president of that association for responding to the Commission's requests with urgency and providing us everything that was required. And we regret if there was any inconvenience caused. The President provided us with the details of the independent specialist. This was communicated to Mr. Karim's attorneys on the 6th of August. It was only on 12 August that the evidence leaders received the treating doctor's report, the report that Mr. Premad has now referred the Commission to. And so the report provides to us, for the first time in this process, a detailed explanation of what is said to have occurred following the ruling on the 29th of July. Whatever may have been occurring between Mr. Karim and his family and the treating doctors, none of that had been communicated to the evidence leaders while we were attempting to give effect to the ruling. The report essentially is an opinion by the same treating doctor as to why Mr. Karim could not consent to an independent medical evaluation, and it provides further material information regarding, clinical information regarding his condition. Notably, it says nothing about the outings that we referred to in the postponement application, the daily outings by Mr. Karim. There is reference to the 14 July excursion to Woolworths and to Kauai, but and that's for the purposes of complaining that it had become public, that it had been made public.
Is the answer to that not possibly that that was dealt with within the postponement application, even by the treating doctor?
Well, it wasn't dealt with in depth it wasn't dealt with from the perspective of what the meaning of that is for Mr. Karim's inability to testify now. And that's what we are concerned with now, is the current condition in the light of these daily outings. I would have expected that would have been addressed more fully, given that it was a significant aspect of from the evidence leader's side, the opposition to the postponement application. But that's not the main, that's not it. The problem, the difficulty we have also with the report is that it's a lengthy report that's furnished 2 days before the hearing without any opportunity for the evidence leaders to obtain a considered expert opinion of the contents of the report, right? As the Commission is aware, there is an independent specialist that the evidence leaders have consulted and would have otherwise wanted to consult on this, but the report is expressly marked strictly private and confidential. medical privilege invoked, not for dissemination, and that it is furnished strictly and only for the consideration of the chairperson, commissioners, and the evidence leaders, that places us in a difficult position because it's prepared at a level of clinical detail, and it says so. The doctor this time says the last reports were for a layperson. This report, he says, is prepared at the level of clinical detail that's appropriate for consideration by a medical professional, but the restriction that's imposed upon its dissemination makes it impossible for us to obtain, for our own purposes, any independent assessment from an expert of that report. So where we find ourselves now is in this circular process, and we keep going around the mulberry bush with respect regarding this witness. And at the time remaining for this commission, and this is the submissions I'd like to make on how we'd go forward, Chair and Commissioners, there's limited time remaining for this commission to complete its mandate. At this point, we submit it's appropriate for the Commission to simply make its findings based on its assessment of the evidence that's already before the Commission in the previous hearing at which Mr. Karim was present, and the evidence that's been provided, and also, for that matter, on the basis that there's certain information that has still not been furnished. The Chair is now familiar with the basic information that we've requested on just financial statements. That hasn't been forthcoming in the interim since the postponement application either. So what we would submit is that the Commission now just makes its findings based on the evidence that it currently has before it, without any further...
What kind of findings do you have in mind? I'm sure you are not referring to the postponement application because the ruling on that application was made on the basis of what was before the Commission at the time of the hearing of that application. So what sort of findings do you have in mind?
Chair, I'm referring to any findings to be made on the basis of the evidence that was led on the 9th and 10th of March. So it's on the merits of what the issues are, whether it shows any of the conduct that we were presenting at the time that we felt fell within the terms of reference of the Commission.
I hear you.
So it's those findings. So the evidence we have is the evidence we got.
Yes.
And let's live with that, is what I'm proposing.
Yes. And what is to be done about the issues that the evidence leaders considered to be still outstanding? There's nothing that can be done in that regard. Conclusions will just be drawn in whatever way regarding those outstanding issues.
Yes, the witness hasn't been able to make himself present to address any of that, and the Commission should follow the normal course as it would in any other hearing in the absence of answers to draw its conclusions.
So if the outstanding matters tell an adverse story on their own without anybody speaking to them, then the Commission may draw whatever inferences in that regard.
Indeed so, Chair. That would be the normal course in any hearing, even in a court. So that's what we propose should happen going forward, except for the following, which I'd like to add as my final submission, and which is that we do request that the Commission records the non-attendance and refers this non-attendance and the record to the NPA or the relevant authority for further consideration for potential breaches of the provisions of the Commissions Act and the regulations. Chair, and the reason for that is that the Commission, through its ruling, has given Mr. Karim a fair and objective route to establish medical unavailability. He chose not to opt for that route. the ruling is clear that the witness may only be excused on the basis of an independent report, and we don't have it. It's not a finding that's going to be made by the Commission. It's a finding that will lie elsewhere, but it needs to be referred to the relevant authority for potential violations of the Act. Those are my submissions, Chair.
Thank you, Mr. The recommendation is being made. Someone would just go to a charge office or write to the police and say, a charge of ABCD is being laid. So that's laying a charge. It's not recommending that a charge.
Yes.
And then it's for subs to investigate or look at the information given and then saying, because of the authorities that Mr. Premhid referred to, there is no case whatsoever here, and therefore they refuse they do not even take that docket to the NPA.
No, that's why I'm saying it depends on the underlying conduct. If you are the complainant going to the, and I say you, I mean obviously ex officio in your capacity as the chair, or the secretary perhaps, because I understand that the secretary is the hand through which a lot of the operations of the commission unfold. So I'm going to refer to the secretary. If the secretary is herself, in her ex officio capacity, the complainant at the police station, then that's why I was saying it depends on the form of the conduct. Then I don't think I could have an Audi objection, because that's as good as, and now I'm going to abuse Ms. Matlingwane's name next to me, that's as good as if I went to the police station and laid a charge against Ms. Matlingwane for intimidation, which is probably coming very soon. She's a very good junior. But I don't owe her a right of Audi. I accept that. That's why I was saying, however, if the secretary is going to write to the SAPS to say, I am recommending that you SAPS charge Ms. Matlingwane with intimidation, and that flows from an ex officio capacity.
Let me right away say, if what I said the commission is minded to do does eventuate, it will not take the form of a recommendation. The commission will just lay a charge.
Yes,
so I think we should just step off this idea of a recommendation.
No, correct.
And let's move on.
Yes, because
that will not eventuate.
Yes, because that also takes me to my original point, which was to say this might not even be the hill for me to die on, because it might be appropriate that any such Audi right is not given effect to in front of you per se, but then in front of either the SAPS or the DPP or whomever, as you ordinarily have the right to make representations to the DPP before any such case commences. So I don't think we are disagreeing with each other. I was only responding to the question Chair posited to me, which was what's the difference and what are the consequences between a recommendation per se and the laying of a charge, and I was trying to engage
how the Audi rights get implicated.
Yes. But because Chair has now said to me that if it is to eventuate, it's not going to take the form of a recommendation, the Audi issue is irrelevant with all due respect, because I think we've come to a consensus that if there's an Audi in the context of the laying of the charge, that must happen elsewhere, not in front of you.
But I'm sure we are agreed that you've made all your submissions.
Yes, absolutely.
So that you don't say, but Chair, you said, are Audi rights implicated at all? And that is you.
No.
And I said, not if it's not a recommendation.
Correct.
You made your submissions on the Audi points and whatever other rights in this regard, and you even came to the point that we are done with our submissions.
In fact,
I just want to make sure
in fact, Chair, you've been so generous to me. Before any decision to recommend or lay a charge has been made, you've invited me to make those submissions in the first place. So I am very, and I did, and I'm very indebted to you for that opportunity, and indeed to respond to what my learned friend said, considering that I was very short in opening, and I'm indebted for that. In fact, we've taken far more time than I would have hoped for, and I apologize for that if that's my doing. So, but I'm indebted to you, Chair. May I just take an instruction?
And Commissioner Baloyi has a question.
Oh, I apologize.
Yes. No.
Thank you. Mr. Premhid, is it not simply this? We are sitting here where Mr. Karim has not appeared, contrary to a ruling that he must appear today. And that ruling had behind it that he would be excused if we get an independent medical report that says he's not good to testify. We're sitting in a place where we don't have that medical report, and therefore there's no basis for us to say he is properly excused not to be here. Aren't we sitting with there is no satisfactory explanation, therefore, for his non-appearance? And then, because our rules do deal with such matters, if a witness is required to appear and they do not provide a satisfactory explanation, certain consequences would follow. Isn't it simply that we're sitting where we do not have a satisfactory explanation because of the issues that you have been ventilating with the chair, but the bottom line of it is that which was prescribed as a basis to excuse him has not been complied with. Therefore, we do not have a satisfactory explanation, and we must deal with it in accordance with our rules. Is it not that simple, really?
Well, I think the danger in characterizing it as being that simple, Commissioner Baloyi, with all due respect, is that then elevates the modality, which is voluntary, but let's leave that to one side, the voluntary of the examination and the excuse to being a prescriptive basis to exclude any otherwise valid excuse. So on your narrow reading, if I understand correctly, Commissioner Baloyi, I can't disagree with you. And the reason I can't disagree with you is because, of course, in terms of what the order specified, non-compliance has arisen. But what I'm saying is I don't know that would be, and I'm choosing my words carefully, I would question the competency of such a directive in circumstances where it's applied prescriptively in that way, and where non-compliance is potentially dealt with punitively because it's a strict non-compliance with the mechanism in the order, to the ignorance of evidence that relates directly to the operation of that mechanism. So I think what I'm trying to say, Commissioner Baloyi, is on your narrow, and I'm going to use the word stricter, reading of the order, then yes, there might be grounds for non-compliance and needing to deal with it. But because of the evidence that is nonetheless in front of you, I would say it's not that simple. Because if the downstream consequences is then lay a charge for non-compliance, whoever has to examine the charge or make a determination of the charge has to look at mens rea and willfulness. And in light of the fact that the evidence is here already to say that there isn't any of that at play, that's why I'm struggling with the narrow reading in the way in which Commissioner Baloyi puts it to me. But I accept what you say in that narrow reading, subject to my caveat.
Well, we're not deciding. The Commission is not deciding mens rea.
Yes,
and
indeed.
we're never in a position to do that.
Indeed.
So leave that out of the equation. All I'm saying is, we have his doctor's report. You've heard the concerns of the Commission about this doctor's report. There was a ruling to try and resolve the issue. That has not materialized. Yes. We sit at a place where he's not here. The Commission is not prepared to accept the doctor's report. You've had the engagement with the chair for reasons that have been given. We end at, well, we don't have an explanation, a satisfactory explanation for his absence. Someone else will determine whether he did have a reasonable, a satisfactory explanation for not appearing. And that's a different process from ours. What we do in terms of rules is to say, on the material before us, he hasn't provided a satisfactory explanation for his absence. And let somebody else evaluate whether that constitutes a criminal offense or not.
No, I think you and I are ad idem on the mens rea and the willfulness point, but when you are sitting, you on bank as the commissioners, are sitting qua commission and are applying your mind as to, do we lay the charge for the strict non-compliance of the order as directed, All I'm saying is that one of the factors you'll have to take into consideration as to whether or not to lay the charge is that there is evidence in front of you that suggests that a charge may be inappropriate for the reasons contained in the medical report. If you, qua commission, choose as the decision maker to ignore that or to give it less weight or to proceed and actually say, well, this is not the form of the report, Chair, this is the debate we were having earlier, this is not the form of the report that I wanted, and therefore only because of the form of the report, I'm going to close my eyes to it and I'm only going to look at strict non-compliance. You're of course entitled to do that, but I would say that that's where my concern and challenge comes about the rationality of such a decision or determination in the circumstances because of the available evidence in front of you. It's that DA versus President Simelane type of scenario that I'm postulating.
The other way of treating your doctor's report and all the evidence, by the way, not just the doctor's report, everything that has been placed before us about his non-appearance over time. Another way of treating it is to say, we've looked at all of that.
Indeed.
We are not satisfied that it provides a satisfactory explanation for his appearance. So it's not simply we closed our eyes as if those are the only things we could do. Is to look at all the material and say, on all of this, we are not satisfied that there is a satisfactory explanation for his absence. And on that basis, we refer.
Well, I think Commissioner Baloyi, if that's what the Commission does, though, because then all the evidence is being considered in the basket of factors, shall we say, before the charge is laid or not laid, then that's procedural rationality met. It means that you follow the correct evidential consideration decision-making process. And I don't disagree with that. A question of substantive rationality.
Trust us to do that.
Yes, no, I've never not trusted you to do that at all. All I'm saying is that procedural rationality might then be met. There could still be the question of substantive rationality, but I understand we're not debating that today or in front of you. All I'm agreeing with you on, I hope, is to say that yes, there is the strict way of interpreting it, but now, as Commissioner Baloyi says to me, trust us that we'll consider everything. Well, that's the safeguard procedural rationality that all I could ask for, subject to any other review grounds that may arise, so to speak. Thank you, Commissioner Baloyi.
At least then I said the Commission was minded to let me outright say the Commission is going to set the criminal process in motion. The Commission will direct the relevant functionary, and as you anticipated it, Mr. Premhid, that functionary will be Dr. Vuguza sitting across there, who is the Commission Secretary, and for her to lay a criminal charge, not to make a recommendation, to lay a criminal charge against Mr. Karim. If the Commission were not to do that, it would itself not be taking its processes seriously. This is something that the Commission just has to do. Otherwise, witnesses will choose to come or not to come testify before it willy-nilly, and we cannot and we will not have that. So the Commission will lay criminal charges against Mr. Karim. Whether he has defenses to that, that's something for him to raise in that criminal process. Thank you. I will not even say that this is what the sort of decision that one usually has in mind in the context of decisions that are taken and which are reviewable. But of course, I can never stop Mr. Karim taking us on review on this, but I would be very surprised if he were to do that. I'm just announcing what the Commission is minded to do. I have a note. I will I will do a trump on my colleagues. Both of them have sent me notes. Two issues. One is that's the end of the road insofar as us having Mr. Karim before us. That's it. Then what's happening next?
Chair, Ms. Ramsamy is ready to continue with her.